Well, thank you for the introduction. Thank you, Philip, for organizing this, and Chris for coming. It's been good to have Chris as a visiting professor at our law school this semester. I'm afraid he'll be leaving us after a few more weeks when the fall semester ends. I don't know if all of you appreciate that today's topic was not quite randomly chosen. It's a good topic of, I guess, some enduring interest, but it's particularly timely because the Supreme Court of the United States is considering, and it's only obviously church-state case this term, a legislative prayer case which arose in a town upstate New York called Greece. The case was argued in the court a week ago yesterday, and the decision should be in hand probably by late spring. So it's timely in that respect, and it's, I think, the best place to start in talking about legislative prayer is to try to establish what that actually is and what the question in the case is, and for that matter, I think what the best way to phrase or put the question today is. So let me start by saying that there's no question about the Constitution requiring legislative prayer of all legislatures or in all courts or at the beginning of all town meetings. It's true, as courts here and there have remarked, that the practice of opening legislative assemblies, court sessions, town meetings, other kinds of public gatherings with prayer is one that began at the founding and has continued, more or less on a steady basis since. No doubt it's less prevalent now than it was 100 years ago, and then less prevalent than 200 years ago. But there's no question about requiring legislative prayer. That's not the issue. Nor do I personally think, although I have the pro position, my view is that the Constitution is compatible with legislative prayer, and I think there ought to be some. I would be the first to say that it's not appropriate, or at least not advisable or prudent in every situation. I can think of situations where, because of the great diversity of religious views and perhaps the presence of some religious tension and controversy in a particular community, that opening any particular public occasion with prayer would do more harm than good, and it could be needlessly divisive. So sometimes it's not the appropriate thing, and it's never constitutionally required, nor by virtue of common sense, by a proper philosophy of liberty, and also by court precedent, is there any question of even where a public assembly of some sort is opened or begins with legislative prayer, is it a matter of everyone who happens to be present on that occasion having to join in? At least since 1943, in a case involving Jehovah's Witnesses and the Pledge of Allegiance, no one really may be required to participate in any legislative prayer. But I do think legislative prayer is compatible with the Constitution, that it's permissible under the Constitution. And that's what I want to really describe and talk about today. But first, what is it? What kind of thing are we talking about when we talk about legislative prayer? Well, there's a definition at hand, and I'm going to use it, and it comes from the Supreme Court's only close encounter with legislative prayer, a case from 1983 called Marsh v. Chambers, arising from Nebraska, its unicameral legislature, which is called the Senate, and its practice of opening Senate sessions with legislative prayer. And the Supreme Court upheld that practice. But I'm going to read to you how the court described or defined legislative prayer. And here's what the court said. Invoking divine guidance on a public body entrusted with making the laws. Invoking divine guidance on a public body entrusted with making the laws. That was the court's definition, if you will, of legislative prayer. In the same case, but in a different part of the case, and a further account was given of what was the purpose or aim of the legislative prayer in Nebraska. So this was part of the case, and it's a little bit fuller, richer description of what was going on. This is a quotation from the chaplain to the Nebraska legislature, a man named Palmer, who was a Presbyterian minister. But here's what Reverend Palmer said he was trying to do when he was called upon, as he regularly was, to open the Senate sessions there with prayer. I strive to relate the senators and their helpers to the divine, to provide an opportunity for senators to be drawn closer to their understanding of God, in order that divine wisdom might be theirs as they conduct their business for the day. So says Reverend Palmer. Well, that's what's upheld by the Supreme Court in Marsh v. Chambers. And the short answer to the question posed, is legislative prayer constitutional? It's the question, I suppose, that's on offer in the case that's pending. The short answer is yes, it most certainly is. That's the court's precedent on the subject. Now, perhaps strangely or counterintuitively, the lower court, the court whose decision is on appeal to the Supreme Court now, held otherwise. The court, in our case, Galloway v. Greece, invalidated the practice of legislative prayer in Greece, New York. Now, therein lies the sort of the difficulty, or at least the questions about this practice. So, I mean to say that legislative prayer, so described, is constitutional, and in general, a good idea. God knows, even if we don't, that most legislators need divine assistance and divine guidance. And it seems to me appropriate, other factors being equal, to seek it on behalf of the legislature. It's not just for those who perhaps have a overly rambunctious idea of divine intervention. It's not exactly that one expects the clouds to part, the light to shine, and the wisdom to be imparted in a way that can be read off. That does happen, but if it happens, it's miraculous. But I think that there's a lot of value to legislative prayer, if for no other reason that it puts legislators in a mood or under a sense, or reminds them that we are a nation under God. And it's one of the curiosities of the case that's pending that while the matter of legislative prayer was challenged, and indeed overturned by the lower court, no one questioned, at least in that case, and there was no issue raised about the Pledge of Allegiance, which was the beginning of every one of this town council meetings. So all of the time, the words under God were repeated by those at least who voluntarily wished to do so at these meetings. And I think legislative prayer has some of the same effects or properties as under God. Just knowing that there's a provident God, that there's a greater than human source of meaning and value, and that we're dependent upon that greater than human source of meaning and value. How many of you ever read Lincoln's Second Inaugural? Probably the greatest testament to a divine or provident God in American history. Well, that's what I'm talking about. And it has a value in those respects. So it's a good idea in general. But there's a certain kind of set of questions that arise about it. So I want to put those bluntly. No, legislative prayer is unconstitutional in the most ordinary or topical sense of that term. The term unconstitutional, meaning according to contemporary Supreme Court doctrine. There is no doubt, I readily concede, I wholly recognize that if the ambient doctrines of the Establishment Clause, and for those of you who are in a church-state course now or have been in one, you'll have heard of the Lemon three-part test, or the requirement of the court that the state public authority remain scrupulously neutral, not only among the different religions, but also between what the court calls religion and non-religion. This aspect of Supreme Court doctrine today does business most ordinarily as something called the endorsement test. Plainly put, the requirement, according to this understanding of the Constitution, is that public authority must not do anything which a reasonable observer would take to be a sign by the government of favoritism, approval, or endorsement of religion. Not necessarily or not only one particular religion, but even of religion as such, over against, again, what the court usually calls non-religion. It's a kind of scrupulous super neutrality. Again, there's no doubt that the practice of legislative prayer is inconsistent with that norm. Let me just think about the definition I read from the Marsh case. It's invoking divine guidance upon this assembly. Well, if that doesn't presuppose and affirm and endorse prayer and the existence of a God to whom one may pray, a provident God, that is a God who's interested in and cares about human affairs, I don't know what would be. So there's nothing religion/non-religion neutral about legislative prayer. So it should come as no surprise, perhaps, or you can readily infer that in the Marsh case, where the court upheld legislative prayer put aside its doctrines. The court quite self-consciously said, we won't apply the doctrines to this matter. I think implicitly recognizing that the matter, legislative prayer, could never survive the doctrines. Instead, the court in Marsh justified its approval, if you will, of legislative prayer by referring to a long and unbroken practice, the history of the founding, and various other considerations, but not doctrine. Not doctrine. Now, in my judgment, that's savvy. As I say, there's no way to pray for divine guidance without endorsing something religious. And I think that's the way we should understand the problem. So if the court reverses this lower court, in our case, and reaffirms the Marsh holding, it will again have to put aside doctrine. Now, in the brief time remaining, I don't want to argue or raise questions about how should a court conceive of and identify those occasions when it simply decides not to apply ordinary law and take a special path. That's a slightly different conversation. What I'd like to talk about instead is what I think the Constitution properly interpreted, although, mind you, not as interpreted by the court for 30 or 40 years, or even 50. Not as recently interpreted by the court, but the Constitution as I think it ought to be interpreted, indeed as it was interpreted for the first 180 or so years of our existence, what it has to say about legislative prayer. Now here I think that the one norm or constraint, thing to keep in mind, call it a test or doctrine, is that as it should be read, the Constitution requires the government not, repeat, not to affirm the truth of any particular religion. Catholicism, Islam, Judaism, Christian Science, LDS, Mormonism, that none of the particular religions ought to be adopted as a state's religion, or if that sounds too much of an embrace, the state ought not to be affirming the truth of a particular religion. So if there were legislative prayer in South Bend or Greece, New York, or Washington, D.C., and it just turned out that all of the prayers were in Yiddish or in Latin, or they were all the Memorare or the Nicene Creed, that if they were all identified with a particular church or a particular faith, well, that would almost certainly violate the Establishment Clause. But here there's a distinction to be drawn, and I mean to draw it, that I think is essential to understanding the Constitution as originally understood, and as understood for a very, very, very long time after the founding. But again, a distinction that's been lost over the last several decades. And I think it's a distinction we need to appreciate why legislative prayer is constitutional, even as the Constitution is properly interpreted. And it's this: to see the value, the meaning, and affirm the value, and to indeed kind of come to a kind of willingness to engage in legislative prayer. One doesn't have to affirm the truth of any particular religion. You don't have to be Catholic to do it, or Jewish, or Muslim, or anything else. Notice, legislative prayer as such has to do with praying for divine guidance, asking for God's assistance, or acknowledging the existence of a provident God. Now, those are propositions about the divine, and it has to do with religion. But those are propositions of what used to be called, and I think still should be called, natural religion or natural theology. Reason is capable of, and I think rightly deployed, would affirm those truths. To put it another way, you don't have to be sectarian in any way to affirm the value of legislative prayer. So a legislature adopting this practice, whether it's the unicameral Senate in Nebraska or the town council in Greece, New York, or the city council of South Bend, or the United States Congress, can say we affirm in adopting this practice, and in doing so, it's affirming some truths of natural religion, not revealed propositions. Now, each of the prayers offered in a series of prayers offered may be themselves, each one different from the others. So again, the value of the practice and its meaning and its basic parameters established by natural religion so far considered the government affirming, engaging in legislative prayer as not identifying itself with a sect. Now the problem in the case from New York is the problem in the Supreme Court, and it raises a fair question. As a matter of fact, in Greece, New York, 2/3 of the prayers given over the course of about 11 years were identifiably Christian. Almost all of the rest were more vaguely theistic, and only a precious few, were minority religions in a sense. 2 were Jewish, 1 was Buddhist, and 1 was Wiccan. So you have predominantly a Christian practice. Now I think this is the source of much of the unease with the practice of legislative prayer. In most places, not just Greece, New York, but in most places, demographics tell you that if you have a kind of random selection of prayer givers from the community, which is what they did in Greece, New York, you're going to get the predictable output. You're going to have mostly Christian prayers. So what about that fact? Does that fact sort of connect with the traditional, I say, original understanding of the Establishment Clause? Well, that's aligning the state with a particular faith. Well, I don't think so. I don't think so for 2 reasons, and I'll just describe them. I won't take the time. I don't have the time to defend them. But I think this. Well, if we're talking about a communal exercise, that is to say prayer, let's say at a meeting of legislators in a room this size, with the legislators in the front 2 rows, 12 people or so, and then just spectators, people from the town in the back. And here we are, and we've decided that it's valuable and useful and good for us to seek divine assistance for these people at our meeting, at the community's lawmaking gathering. We're asking God to give guidance to and share wisdom with these lawmakers. And in Greece, New York, as I think typically, not always, but typically would be the practice, the government recruits almost randomly volunteer prayer givers from the community. But I do think that the prayers in a given community ought to be intelligible and meaningful to the community. It's a community undertaking. There ought to be community intelligibility. And they are prayers not quite on behalf of the government, but as part of this public assembly and for the purpose of bringing to bear what one can of divine wisdom on this public assembly. So my judgment, my submission is that prayers in legislative assemblies ought to be representative of the surrounding community. And so long as the government is not rigging it to exclude this minority faith or that minority clergy person, just so that the prayers turn out to be, and they are desired to be, it's the desired end to have prayers of a particular sectarian type, then the fact that they reflect the community's beliefs, I think, is appropriate. And to put it maybe the other way around, it would seem to me perfectly inappropriate to have prayer givers at a meeting in Greece, New York, praying to a God that no one has heard of, nor understands, nor even that anyone present actually believes exists. And that's not a fantasy. One of the prayer givers in Greece, New York, was a Wiccan priestess who didn't really pray in any identifiable way to any kind of Wiccan divinity or deity, but actually prayed to Athena and Apollo because she thought that would be cool given the name of the town. Well, I don't myself think it's cool, but I think it's actually kind of a pointless exercise. It defeats the purpose of having the prayer in the first place, to make it into a kind of farce or a show, or even some attempt at bringing in the most exotic possible set of beliefs just for the purpose of being diverse. I mean, legislative prayer as an undertaking, it's not like having karaoke at a public meeting, where it's just like everybody get up and say whatever you want. No, that's not prayer. Nor is it really an opportunity for everybody to offer whatever spiritual sentiment they happen to hold, which they think would in some way solemnize the meeting. That might work, but it wouldn't be prayer. Okay, you have somebody maybe who comes forward when the call for prayer is announced, and they might say, well, I don't believe in God, and I most certainly don't pray, but I play the sitar, and I can hum. So I think that will settle everybody down and give a kind of spiritual glow to the thing. I think that's inappropriate. It's not prayer. So in sum, and these are my last remarks before the question and answer, I think that the meaning and purpose and nature of the prayer that is seeking divine assistance is the anchor of the practice. And from it, you can reason out to kind of a rough set of qualifications or types of undertakings that would count as that sort of prayer. And that's really the nature, you might say, the limitations that are appropriate to the practice. Real prayer to a real God, and anyone who's willing to do that should be, and I think would be welcomed at a public assembly.
All right, so first of all, it's a pleasure and a privilege to be here, to be discussing all this with you. I'm grateful to Professor Munoz and the Tocqueville program. I'm also grateful to Professor Bradley, who I've learned a lot from over the years, and who I actually agree with on many matters, although you probably won't see any agreement today. And because this is styled as a debate, I'm actually going to try and do my best not to agree with Professor Bradley on anything, no matter how compelling I find his logic, although maybe we agree that Congress is definitely in need of some divine intervention. So the issue in Greece versus Galway, I'm going to reframe it, is whether citizens have the right to participate in local government meetings without having to participate in coercive and overly denominational prayers. That's the way the plaintiffs see Greece versus Galloway, and I think it's worth viewing it from that side as well as the other. Plaintiffs live in the town of Greece in upstate New York. The town of Greece has monthly board meetings. Board meetings open with prayer from invited local clergymen. Clergymen are almost always Christian. From 1999 to 2007, every prayer giver is Christian. Later on, there's some diversity, as Professor Bradley mentioned. There's a Wiccan priestess, there's a member of the Baha'i faith, there's a Jewish layman. But all the diversity happens only after the threat of litigation, and it's only a brief flicker. From that point on until the record closes in 2010, it's again true that no non-Christian gives the prayer. The town says that they would accept anyone as a prayer giver, but they don't make any effort to publicize that fact. The prayers are pronouncedly Christian in tone. They often refer to Jesus Christ, often at the end in Jesus' name. Many of them make extended statements about Christian doctrine. They talk about the incarnation and the resurrection. They talk about the salvation of Christian believers. And we're trying to think about how it would feel to be in that room and be Jewish. Some prayers go further. They impugn religious minorities and non-believers. One prayer is offered in the name of all God-fearing people. Another calls dissenters from the prayer minorities and says that they're ignorant of the history of the country. Prayers often treat the audience as Christian, and this is common. Prayers refer to things like our Christian faith and us as a Christian people. Prayers request that everyone join in the prayer. And people who don't participate are noticeable. The board is only 10 feet away from the audience, right, as close as you are to me. They can see you. They'll obviously notice if you try to leave for the prayer and then come back. They'll obviously notice if you do anything to object to it. But they're also going to notice if you simply don't join in. Right? If you don't bow your head, if you don't appear to be reverent, they're going to notice. And remember, these people have power over you. Right? Citizens attend town council meetings because they want, often, the town council to take action for them. They want a zoning permit, or they want an end to the nuisance that's being caused by their neighbor, or they want an accommodation for their disabled child attending public school. And maybe the town council won't hold it against you if you refuse to pray. But you don't have any way of knowing that in advance. And the town council has only 5 people on it, so every vote is crucial. Some people have to attend the meetings. Not many, but some. Some have business there that they have to get settled in front of the town council. Town employees have to attend. Police officers take their oaths of office there. They have to do that. Children attend to fulfill school civics requirements. Plaintiff's claim here is that this prayer scheme is unconstitutional. Not other prayer schemes, but this particular prayer scheme. This particular prayer scheme, they say, is too coercive and too denominational. The town could have done a number of simple things, the plaintiffs say, to make this less coercive and less denominational. It could have put some time in between the prayers and the business of the meeting. It could have asked the chaplains to pray in the kind of civic fashion that our military chaplains do and our congressional chaplains do. Plaintiff's claim here is not that all legislative prayers are constitutional. You could understand that kind of claim. For the past 60 years or so, the courts have required the government to generally be neutral on theological issues. The government can't favor one religion or religion in general. But that's not the plaintiff's claim for reasons that Professor Bradley talked about. The 1983 case of Marsh versus Chambers, the court upheld the legislative prayer practice of the state of Nebraska. Nebraska had a permanent chaplain that opened up legislative sessions. The court approved the practice, stressing that the practice of having legislative chaplains went back all the way to the first Congress, went back to 1774. Right? First Congress hired chaplains and passed the Establishment Clause of the First Amendment. That was good proof, the court thought, that chaplains in legislative prayer don't violate the Establishment Clause. Plaintiffs are not arguing to overrule Marsh. They're arguing within it. And there's some foundation for that. Right? There's disagreement with the court, in the court, on the endorsement test, on the Lemon test, for reasons that Professor Bradley began to get into, about whether the government really needs to be strictly neutral on matters of religion, whether the government can maybe favor religion in general. But there's widespread agreement, both on the court and off it, and Professor Bradley indicated some support for it too, that the government can't favor one particular religion over others. And that's what this case is about. Right? There's disagreement on the court about whether the government can ever make religious statements, but there's widespread agreement on the court that the government can't coerce, and that too is what this case is about. Marsh versus Chambers ends up being very different than this case. Right? They both involve legislative prayer, but they are very different. Marsh versus Chambers didn't involve denominational prayers. Court specifically noted that the chaplain in Marsh had dropped references to Jesus Christ after there were some complaints by a Jewish legislator. Court in Marsh said that prayers would cross a line if they disparaged or proselytized or advanced any one faith. Prayers in Marsh, the situation in Marsh wasn't coercive in the same way that it was here. Right? Congress and states often have chaplains to open up sessions in prayer, but the prayers are infrequent. Attendees aren't asked to participate. They move in and out of the chamber during the prayer, so dissenters never have to stand out. And perhaps the most important, prayer givers before Congress, and in most of the states, 37 of them, are given a lot of guidance on how to pray. They're told explicitly to be non-denominational, to be non-sectarian, to remember that they're giving a prayer to people who don't agree with it. Right? So far I've been addressing the issue in Greece versus Galloway, talking about that. I want to turn a little bit to the larger issue about legislative prayer in general. I was given mixed signals. I think we were both given mixed signals about whether we were debating legislative prayers in general or Greece versus Galloway. So let me just turn to that a little bit too. Marsh versus Chambers, I think, is a really difficult case. The court's opinion is grounded almost entirely in the historical fact that the first Congress hired chaplains. And that historical fact is undeniably true. But there's an issue about what that should mean for us. Right? The first Congress hired chaplains, which is true enough. But the first Congress also punished larceny by public whipping, up to 39 lashes. Even though everyone nowadays, almost everyone, thinks that whipping criminals would violate the Eighth Amendment's prohibition on cruel and unusual punishment. 10 years after the First Amendment was enacted, Congress passed the Alien and Sedition Acts. Everyone nowadays thinks that would violate the Free Speech Clause. Of course, it's not just that the first Congress hired chaplains. There are other examples of support of religion at the founding. Presidents gave Thanksgiving proclamations that thank God. Since Washington, the presidential oath is concluded, "So help me God." There's "In God We Trust" on the coin, "Under God" in the Pledge of Allegiance. There are a number of other things. Of course, it's a mixed practice there. Jefferson refused to issue prayer proclamations. He said they were unconstitutional. Madison, this is typical for Madison, issued prayer proclamations and then regretted it. concluded that they were unconstitutional. And so this is a persistent problem that the court faces whenever it does constitutional interpretation. Constitutional practice is inevitably mixed. There are two sides in every fight, and when a constitutional provision passes, it doesn't end the debate. The losing side doesn't go away, right? It retains power. And in a system like ours, where power is spread among levels and branches of government, the losing side will still have a large share of the victories. And even worse, those who agreed on a provision, like the Establishment Clause, probably won't have agreed on how it might be applied, especially because the issues that we're most concerned about now aren't the issues that they were most concerned about then. The big issue at the framing of our Constitution was how the church would be funded. Right? Would churches be funded by voluntary donations, or would they be funded by the government? Framers came to oppose tax support for churches, but they didn't talk much about non-financial support for religion. It wasn't a live political issue. It wasn't something that the federal government then did very often. That question comes into focus only much later. It comes into focus in the 19th century, when migration patterns put Catholic immigrant school children in Protestant schools, and those Catholic school children are suspended, expelled, beaten for refusing to recite Protestant prayers and read the Protestant Bible. And then in the 20th century, when Jews and other non-Christians similarly find themselves at odds with a public school system that's markedly Christian. The attractive principle, I think, that comes out of the founding, but it's reinforced and reapplied in different situations over the next 2 centuries, is that the government doesn't take positions on theological questions. The government doesn't decide whether Jesus is divine, whether transubstantiation is true and right, or even whether God exists. So let me say this. I don't think the court will overrule Marsh versus Chambers. Doing so would, I think, necessarily imply the invalidity of the congressional chaplaincies, and the court is not going to intervene that deeply into the affairs of a coordinate branch. The congressional chaplaincies are large. They have budgets in the millions of dollars. The court is not going to strike that down. And so I'm not really asking for the court to overrule Marsh versus Chambers. I don't think that would happen. I don't really want that. What I want is for the court to maintain course. Right? There's steady pressure now on the court to make exceptions to the neutrality principle or to abandon it altogether, to give up the fight. And I think that would be bad for religious liberty. I think it would be bad for non-believers and religious minorities. But I think it would also be bad for mainstream believers, for mainstream Christians, and for the fabric of our republic. People have a quite rosy view of legislative prayer sometimes. But I think it's often because the troubling situations with it have sometimes gone on under the radar. There are a lot of modern controversies over legislative prayer, and I think maybe they illustrate the difficulties of having something like legislative prayer in a pluralistic society. So the most obvious problem has been with offended listeners. I mean, that's the issue in Greece versus Galloway, and I think maybe we've been too quick to write off these people as overly sensitive. But offended listeners are just the tip of the iceberg, right? Some of these plaintiffs in the cases are would-be prayer givers. One case involved a Wiccan clergy person who signed up to give a prayer and was sent a letter saying that her town didn't want Wiccans. Right? Maybe sort of a logic along the lines of what Professor Bradley talks about. Right? That doesn't look like a prayer to them. Another involved a county that invited clergy but deliberately excluded Muslim, Jewish, and Mormon clergy. And other kinds of weird problems develop every now and then with legislative prayer. If prayer givers suddenly go off script, they say that they'll stay within the limits that are set by the city council, that they won't proselytize or disparage other faiths, but they don't stick to that. They proselytize, they disparage. One recent case involved a prayer giver who went off script, started praying to end abortion. Another started praying for the ordination of gays and lesbians. And the issue becomes, what does the town do? Does the town try to sanction those people? How are you going to punish them? Or prayer givers get interrupted. Right, in one case, a Unitarian Universalist offered a legislative prayer. Prayer was thoroughly, scrupulously non-denominational, what you would expect from a Unitarian. She gets interrupted by people in the audience praying over you. Praying over her. Same thing happened in the United States Senate a few years ago. They invited a Hindu guest chaplain who got interrupted by protesters in the balcony. Protesters got 6-month prison terms. When the government takes religious positions, those religious positions become things to fight about. And they're fought about in the usual domain of ordinary politics. Right? Local elections have been decided on legislative prayer issues. One small town in California was recently considering a ban on denominational prayers that were overly denominational. A citizens group responded by purchasing billboard space on nearby highways. The billboards would publicly display each council member's vote as either being for Jesus or against Jesus. One case decided this year involved a referendum. The city barred overly denominational prayers. There was a referendum in response, and the referendum read like this: shall we have an invocation policy that allows prayers to Jesus Christ? 12,000 votes cast, 76% in favor, 24% opposed. So maybe we shouldn't be surprised at all this, right? This is what happens when the government takes religious positions, right? People want the government to take their religious position. They campaign for it, they vote for it. I think all that's natural. I think all of that is inevitable once the government starts taking religious positions. And so if we share the idea that there's something troubling here, maybe what we share is that the idea that the government shouldn't be taking religious positions. So that's all I have. Thank you. We can start the Q&A.
Let's open it up. Gerry, maybe you and Chris want to ask a question or two of each other first, but let me get my own question in first. Did Jesus win his election in California?
Did he win his election? Well, yes, 76% of the town said...
Not the referendum, but when the city council members pro or against Jesus.
Oh, I don't know what happened with that. I gotta find that out. I knew that they put up the billboards. I don't know who ended up won. No, it was rural California.
Gerry, why don't you guys both come to the podiums and give, would you like to, Gerry, do you want to get a question into Chris? Chris, one or two, or Chris vice versa?
Well, I think I agree. Whenever government gets involved in debates about what human rights require, people get really mad and divide up and suspect other people of ill motives. So the question is whether everybody should have right to access to health care, or whether capital punishment's right or wrong, or whether immigrants are really like us or not, or whether we should leave a climate, an earth that's not boiling over for our kids. I think people get pretty upset and think that other people's motives are suspect, and maybe even feel like outsiders at meetings where those issues are debated and where one senses that one's in a minority, as I do at most faculty senate meetings, for example, and as most of you probably do at the meetings in your dormitory. And what follows from that, I think, is the real issue. And if what follows from that, when the question has to do with religion, or with what one person arguing says has to do with religion, and then we'd have to argue about whether it really has to do with religion. So those people who think immigrants should be treated rightly because Jesus died for them and they're our brothers and sisters, or capital punishment's wrong because everybody has a God-given right not to be killed, well, then we'd have to put that off the table. But we don't put it off the table because we realize that those are arguments that people need to have in a well-governed polity. And my own judgment is that for better or for worse, in some respects it is for worse, religion is about the least divisive matter on the agenda of most public assemblies. Whether it's Obamacare, terrorism, data mining, or the environment, or capital punishment, or abortion, or same-sex marriage, I could probably go on until Philip says you must stop, with divisive issues before coming to religion. So I think that the kind of viewpoint that Professor Lund offers, where people looking at the array of folks at a town meeting and recognizing this would be a spectator, that I'm not really quite like them or with them in religious matters, I think that that's about 100 years, or at least 50, out of date.
Yeah, I think Professor Bradley's right that alienation in politics is inevitable. The government's going to have to decide how to punish criminals, whether to adopt the death penalty or not. It's going to have to decide whether to allow abortion or not. It's going to have to decide whether to allow gays to marry or not. All of those things are going to cause feelings of alienation. But our experience with religion is different, right? The experience of the framers, I think, was that the government didn't have to decide matters of religion, right? It could handle all the governance issues it had to handle without having an established church. right, without deciding on these theological questions. That the government could do its job without deciding whether Jesus is divine, whether transubstantiation is true, or even whether God exists. So I just don't see these things as the same, really.
That's to say that they're not different because they're divisive and other things aren't. I think what you're saying is it's just irrelevant. If religion's an irrelevant thing which is gratuitously interjected into public assemblies where, frankly, religion doesn't belong. Now, I don't entirely agree with that, but I wonder how you would deal with the objection that everything you name, same-sex marriage, the death penalty, immigration policy, health care, terrorism, torture, they're all religious questions. Now, they're not theological in the way that Jesus' divinity is, but I dare say, I'm guessing this is what a survey would show, that most people take the views they do on those issues because of their religion.
I think that's all true, and I don't think the government can stay out of those debates because the government has to decide those issues. I think religious arguments in politics are constitutionally protected and perfectly legitimate. Right? Both sides are going to make religious arguments, and you see them making those arguments with regard to all the issues that you were talking about. All that is fine. I think the only bar we're talking about is a narrow one, right, on the government answering sort of quintessentially theological questions. And the experience, this grew out of an experience that wasn't that, particular issue wasn't necessary to governance.
Should we open it up to some questions? At the Constitutional Studies minor, we like to ask our undergraduates, or invite our undergraduates to ask the first question. So any undergraduates like to pose a question to one or both of our speakers? Sure, yeah. And stand up and introduce yourself.
I'm Dan Wayo. I'm a senior political science major. You noted that this is for Professor Bradley, you noted that there would be instances where having opening legislative prayers would be bad. Can you point to specific instances of that and maybe say why that would differ from the case here in Greece?
Well, I did say that. I'm not sure if I would say it differs from the case in Greece. Now, Greece has given rise to a lawsuit, but nonetheless, I'm not sure that I would think that the evidence shows that it's inappropriate in Greece. But my point was simply that there can be situations where, given the tensions in the community, if there's been division already in a particular community over some religious issue, or if experience has shown that the selection process for volunteer prayer givers seems never to work to everybody's or nearly everyone's satisfaction, well, the question arises with legislative prayer, as with anything else, whether raising it as an agenda item or including it on the agenda does more harm than good. Now, that's true with just about anything that might be on an agenda. Now, sooner or later, there are certain questions that need to be taken up, whether it's the traffic signals or the county budget, and you can't put them off indefinitely. Well, that may be true. But I think that the issue between Professor Lund and I may be not so much about relative importance of concrete issues like capital punishment, etc. I think his view really is that the religion thing is just not important at all. I disagree with that. I said all too briefly in my own remarks that I think that instilling in legislators, for that matter, us, everyone, a sense of dependence upon something greater is good for the soul. Indeed, I would go so far as to say, I would even assert that people of different religious faiths coming together in a public assembly and trying to work together to solve their common problems, I think actually bringing them to mind of a greater than human source of meaning and value, that there's a provident God out there, is liable to still lessen, diminish their prejudices than to increase them. And that we all have to deal in public assemblies, even private assemblies, with people who are different than us. And the appeal to a kind of sort of hopelessly incendiary potential to raising questions about God, and that just simply isn't something that our political system can tolerate. Well, I think that's a proposition that would have to be proved and not just asserted. It may be that it could be proved 200 years ago. Maybe it could be proved today in some places. Whether America is one of those places, America now, I doubt.
Chris, did you want to get in on this one?
Yeah, I'm not saying that religion's not important at all. Right? It's profoundly important. Right? That's the problem here. When I said that religion wasn't important, what I said was that religion wasn't important to governance, and that was our experience. Right? It's precisely because so many people are, powerfully attracted or repelled by religion that sort of creates the problem that we're all dealing with. Right? And I understand that there are honest people, right, who sincerely want the government to embrace their religious views and see that as part of their religious commitments. And it's an imposition on them for the government to remain neutral on religious issues. I understand that. It's just something I can't fix. It's not a right that can be shared equally, right? If we have different religious views, and if the government adopts my religious views, then it can't adopt your religious views. And I kind of regret that that's the case, but it is.
Another question? Yeah.
My name's Stephen. I'm a senior political science major. This one is also for Professor Bradley. Professor, you said that the Constitution properly interpreted for you would mean that the government would not affirm the truth of any particular religion. What would you have to say about a lot of state legislators I know elect their chaplains, and in the case of Marsh versus Chambers, I believe the Presbyterian minister had been elected for something like 15 straight years. What would you make? Would you say that having a minister of a particular faith being elected over and over again, like say a legislator elected a Catholic or a Jew for 100 straight years, even if he was giving a non-sectarian prayer, do you think that would point at any kind of establishment?
Yeah, I think if you had 100 years where the same guy was elected, first you'd have a very old preacher, and number two, you'd have a prima facie case of a certain kind of bias, right? I mean, if you have one person out of many eligible individuals, but he always was. I'm not sure if Reverend Palmer in Nebraska was elected. He held his office at least for, I think, 16 years, but he might have been appointed by the head of the Senate or some other kind of leadership body, or maybe even a leadership person. But nonetheless, I would readily agree that there can be prima facie evidence of an inappropriate bias. As I said, all the prayers, despite protests from the town council that were soliciting random volunteers, if they were all in Yiddish, or if they were all to Allah, well, you would suspect that what appears to be an open opportunity for all volunteers in theory, or so stated, in fact isn't. And if it isn't, then it's wrong.
Hi, I'm Maggie. I'm a sophomore political science major. This is a question for both professors. Professor Bradley, you were saying that it would be a bad idea in situations of very high tensions to start with a legislative prayer. Do you think that prayer should then be continued in the case of Greece? And if, because of the high tensions, it's obviously got the Supreme Court, tensions aren't exactly good right now. Do you think it should be stopped? Or if not, how can they continue it and make it a more equal experience for all religions?
Well, I wouldn't say the tensions are high. I mean, there's a lawsuit. I'm sorry, go ahead.
Just repeat the question to make sure we get it.
Yeah, the question had to do with whether in Greece itself, which is the area of the lawsuit came from, the tensions are such that I would think it would be better to discontinue the practice, or if not, how would you pacify things? I don't think the existence of a lawsuit itself proves a level of tension that requires real reform. No doubt these two plaintiffs, these two women, are displeased. I think Chris used the term kind of offended listeners. Well, that would include all of us during any given meeting, and maybe for most meetings. So I don't myself place the value, or we're put in the kind of constitutional cockpit, the offended listener. Most of us are offended by what public authorities do most of the time. So the offense thing, I don't think carries the weight that perhaps you would argue it should.
So you think they could still continue legislative prayer?
Well, I think they could. I'm not sure what their practice would look like now. All we know is what the practice looked like between 1999 and 2010.
Professor Lund, is there a way for that you think would be compatible with the Constitution for the town of Greece to do its legislative prayer? Are there reforms, or do they just have to end it?
That's not what the plaintiffs are asking for. They're not asking for an ending to it. They're asking for the chaplains to be instructed, to be given some instruction to be non-denominational and non-sectarian, and also to separate in time the prayer from the meeting. Frankly, one of their issues is it's not clear exactly what they're asking for.
I see. And in your judgment, what would be constitutionally appropriate?
I don't know. It depends. I mean, the issue of remedy goes back to what the issue of the injury is. I mean, I think those two components might be, good components of remedy. I haven't really thought about that issue.
Other questions? Sure, Ryan.
Ryan Gonzalez, senior political science major. I invite both Professor Lund and to answer this question, even though I'm going to reference something that Professor Bradley just said. Professor Bradley just said that if a practice isn't open to everyone, then it's wrong. But doesn't legislative prayer disqualify non-believers and atheists from participating? This doesn't seem like a practice that non-believers can participate in at all. It seems to favor religion over non-religion in that even though it doesn't affirm the truth of a particular religion, it does affirm the fact that a God exists and one God and not several or not at all. So.
Right, I agree completely.
Hey, Gerry, can you repeat
yeah.
the question again?
Yeah, the question is, well, at least the relevant part was that I said it should be open to everyone, but that's not really realistic because at least you'd be limiting it to people who are willing to affirm or endorse, if you will, that there's a God. I think I did say earlier, a provident God. I don't remember saying it should be open to everyone. If I did, I didn't quite mean it that way. What I surely did say is that the nature of the undertaking, which I described by reading from Marsh and then in my own words as seeking divine assistance for this body, that undertaking sort of intrinsically sets the qualifications. So to say, for example, I'm not sure if you're asserting this, but some people in arguing about this case assert this. Well, sure, you can have legislative prayer, but you have to make sure that devil worshippers, atheists, and all sorts of people who don't believe in God get to do it too. And I would say, well, no. Well, of course, unless you want to abolish legislative prayer and replace it with something else. Now, you can have something else, and sometimes it's described as you should have an opening invocation that solemnizes the proceedings. I'd be the first to say you don't need to pray to do that. You could read the Gettysburg Address. You could read a letter from Iwo Jima. You could play the sitar. You could read Walt Whitman's poems. A person could reflect upon their most challenging and difficult childhood experience. We could all meditate. There's any number of things that would solemnize an occasion, lend it a kind of air of seriousness, have people recollect themselves. And that might be worth doing. But that would be to abolish legislative prayer and replace it with something else. Similarly, you could say, I said kind of casually, looking for a laugh line earlier, that it really could just be like karaoke at town hall. Like everybody gets a chance to come forward at the beginning and for a limited time, 3 minutes or whatever, to unburden themselves. Well, that wouldn't be what I would choose to do if I were running things, but one could do that. But that wouldn't be legislative prayer either, even if some predictable percentage of people who took the microphone at karaoke prayed or did something that looked like prayer. Some would, many would not, but the practice would not be the practice of legislative prayer. So yes, if you're going to pray to God for assistance for these lawmakers, I think exactly right. That presupposes several truths. God listens to prayers, God hears prayers, God is interested in what lawmakers do. And not only non-believers, but many, many believers do not affirm those propositions. So my main point is, you may be making an argument that's valid in a certain way, but it's an argument against legislative prayer.
Do you want to get in on this?
I think he's right.
Okay. So you'd say no, and therefore you shouldn't.
Well, I
have
mean,
the prayer.
I think it's right. I mean, legislative prayer is prayer, and it's religious, and under the endorsement or Lemon test, it would be unconstitutional.
Okay. Let's see, Nick, and then we'll open it up to everyone.
Yeah, I'll Stacy.
Yeah.
Nicholas Schilling, I'm a senior political science major. My question is actually for you, Professor Lund. You framed Greece as that the plaintiffs are arguing that it's too coercive and too denominational.
Right.
The court has generally avoided judging the religiosity of particular actions or behaviors. So how does the court address the plaintiffs, how you frame the plaintiff's argument without judging, this is too Protestant, this is too Catholic?
Yeah, I mean, the court would have to make those judgments, and it has been something the court has been worried about. It's actually a line-drawing problem that the right-hand side of the court, the conservatives on the court, have had to deal with more than others. So Justice Scalia's position in the school prayer cases is that school prayer is okay as long as it's non-denominational. His position with religious displays was that displays like Ten Commandments displays are constitutional because they're non-denominational. And of course, this requires a line to be fleshed out between the non-denominational and the denominational. It's not at all easy to do. In his opinions, he's sort of come up with a line that's based on the three monotheistic faiths, Christianity, Judaism, and Islam. And he says anything that's acceptable to those three faiths should be considered sufficiently non-sectarian to be permissible. It's kind of what the plaintiffs are spitting back at in this case. They're sort of saying to Justice Scalia, there is a navigable line, and you've provided it. And it's amazing, at oral argument, he was able to attack it anyway, which is, he can do anything. No, I'm actually in praise of that. But yeah, I mean, it's a very difficult thing. I mean, I think, in the middle, the line between sectarian and non-sectarian, denominational, non-denominational is very murky. But at the extremes, the difference is clear. There are a lot of prayers that just refer to God or Heavenly Father or the Almighty. Those are clearly acceptable. There's a long tradition of civic prayer in this country. There are guidelines given to people who pray in front of the House of Representatives and to the military chaplains that talk about, this is how you pray in front of a very mixed audience. I think you could draw a reasonable line through that, although, right, in the middle, there are going to be difficult questions.
And that's okay? That's consistent with the Constitution in your mind, even those...
Well, I mean, I don't know whether I'm defending the plaintiffs in Greece versus Galloway, because they're willing...
Professor Lund's point of view.
Yeah, I'm a critic of Marsh versus Chambers, so I am not a fan of legislative prayer in general. But if we're going to have legislative prayer, it seems to me like there have to be some protections, right? We're trying to manage the problems that are arising from Marsh versus Chambers, and this seems like a reasonable way of doing it.
Okay. But in your reading of the Constitution, Marsh v. Chambers, it would be the right result would actually be to overturn that precedent.
Yeah, I think that's right.
Okay.
I think that's right. It asks for a lot. It asks for more than the court is willing to give.
Yeah. Professor Bradley, you want to get on this? Okay. Laura, please.
Hi, I'm Lauren. I'm an accounting major and a public service minor. I'm a senior. My question is for Professor Bradley. I'm just wondering, what is it about your idea of divine assistance that needs to be sought out loud? Could that be obtained through maybe a moment of silence or something like that, so that maybe there's a culture of us and then with regards to the prayer giver?
Well, I'm not sure. There's two parts to the question. One is whether a moment of silence would have the same effect or has the same properties or is the same as prayer. And the answer, I think, is no. A moment of silence may serve the purpose of recollection. It's a pause and it marks a transition from preliminary chit-chat or whatever and the real deal, the business agenda. It has a purpose and function, but I just don't think it's prayer. Now, it's not a matter of what I think about divine assistance and whether speaking out loud as opposed to speaking inwardly is more efficacious. I'm not sure if that's the question. I mean, it's not either or, to say the least, but obviously the point of legislative prayer, let's say speaking out loud and speaking words that amount to an appeal for divine assistance, well, it's meant to be a communal or collective undertaking at that point. I mean, it's really the body that is involved in that. Even in Greece, where volunteers are brought in who are not members of the legislature and, as far as we can tell, have no other business before the town council but to be the volunteer prayer giver. I mean, it's the board's meeting. It's on, you might say, the public dime, and it's for that assembly. That's the exercise that I described, an hour ago by looking at Marsh First Chambers. And that simply is a different thing than even if each one of those persons, during a moment of silence, prayed for divine guidance for himself or herself. And I think that's the reality, such as it is, in saying the Pledge of Allegiance at these very same meetings every time. And you say one nation under God, there's a kind of recognition of this provident reality that is greater than we are. Now, plenty of people think there is no such reality, and plenty of other people wonder whether that reality is any more interested in what people do. And even some believers think that whatever that reality God is about, God is definitely not interested in blessing human government, which some people think is blasphemous. God is the sovereign, not the people or the representatives. There are a lot of opinions about the meaning and value and validity or truth of legislative prayer. But I don't think it's the case, and I don't hear Professor Lund saying this, that the constitutional issue depends upon the truth of that matter. And I think that's correct. That is to say, whether it's constitutional or not, I think doesn't depend upon, just for example, the Supreme Court getting 5 votes for the proposition there is a God. Now, I think people who engage in legislative prayer would do so very, very often, largely because they believe in what they're saying, but not everybody. There's been more than a few people who themselves are non-believers who think that, you know what, if the plebeians and the rabble pray, it's better for the community. It makes them more docile. So again, you can be in favor of legislative prayer and maybe even recite the words at the meeting, but believe in nothing, but a kind of conservative effect, you might say, upon the community. But again, I don't think the constitutional issue devolves down upon the truth of the matter.
Okay. Abby?
Hello, my name is Abby Davis. I'm a sophomore political science major, and my question is for you, Professor Bradley. Towards the beginning of your speech, you said that there's no doubt that under the Supreme Court's different Establishment Clause doctrines, that legislative prayer would be unconstitutional, and you specifically talked about Lemon and O'Connor's endorsement test. Mm-hmm. And as I was listening to your speech, it sounded almost like you were favoring maybe more Rehnquist non-preferentialism, but in response to another question about whether certain types of prayer are basically just essentially preferring certain types of religion over another, you said that that's not necessarily an issue. So I was wondering if you could tell us, if you were on the Supreme Court, what would your doctrine for the Establishment Clause be and why?
Okay, it's a good question. So what, do I get paid extra for kind of, solving these, thorny chestnuts of constitutional law?
It's like I planted these questions in the other.
Yeah. And this is great. When you're an academic, been teaching law for 31 years. You teach for 31 years, eventually you get to say this. Well, of course you could read my book, right? Scouts on it. I wrote a book which answers this question, frankly, Abby. Published in 1987, and it's still selling. Literally, I got my royalty statement last week. It sold 2 copies. But I only made 13 cents because there was 1 return. So last year there was 1 net, and it obviously wasn't you. So next year I'm going to sell a copy. But the answer is, I spelled it out. It's no secret. I do think that the meaning of the Establishment Clause then should be now, is that the government's disabled from affirming the truth or falsity of any theological or sectarian proposition. It's pretty much the test for free exercise now that you get in Lukumi Babaluyai. When you look at that case, the case after Smith with the Hialeah, Florida chicken Santeria religion, you kind of look at it, they quote Locke, they quote this. That's pretty much what they're saying the meaning of free exercise is. No government affirmation or denial of a theological or sectarian proposition. I think that's right. I think it's basically what the Establishment Clause means. Now, I should hasten to say, and here respectfully disagree with Professor Lund, I would not lump together, as he did, Jesus' divinity, transubstantiation, and the existence of God as all similar religious propositions, or theological, if you will. They're very different propositions. The last is something that could be true or false, but it's certainly something that can be shown to be or argued as true or false on the basis of reason. It doesn't depend on revelation or the holy book or some clergy authority figure. So there's a difference between religion, you might say natural religion, and positive religion, or the churches.
Let me just respond just a brief bit. I think, Professor Bradley, I'm curious what you think about this. There seems to be a tension here, right? You talk about how, in a sense, right, these citizens, the clergy, they don't want to just pray on their own behalf or with their congregations. They don't want to pray, before the meeting or personally by themselves. Right? They want to pray on behalf of the government. They see something really important about that. But then at the same time, earlier you were talking about how, and your position seems to be that when the chaplains pray, they're not really praying for the government, right? The chaplains can, assert these theological claims, right? They can talk about Jesus Christ and make all these claims, and that's not really the government making those claims. And I don't understand how those two things really fit together.
Well, let's say, for example, when you have people, 4 senators get up this morning and argue about what they should do about fixing Obamacare. Now, they're each officers of the government. Mm-hmm. Each is in the Senate. Each is speaking while the Senate's in session and on the record. But they say irreconcilable things. So they can't all be speaking for the government, right? Because then the government would be speaking gibberish. So when I say that the chaplain, even if it's a volunteer from outside, becomes part of the assembly, I can't think of any other way to properly construe it unless one falls into a kind of karaoke at town hall kind of thing. And I can't think of any reason why a public body should be there for entertainment, the entertainment of individual persons and vice versa. I think that's just not worth doing. So when you have legislative prayer, you have, even if it's an outsider praying, you have an act of the body. It's for these people on this occasion as a public body. So they speak, I don't know if it's not tricky, I mean, they speak in their own voice, but for the group. And I think that happens commonly with, assemblies. I mean, to put it differently, no one should ascribe to the entity everything that anyone in the entity says. You can't really do that. So you argue back and forth in the Senate for 2 days about filibustering a nominee to the court of D.C., but the Senate voted whatever they voted, 58 to 41, to end the nomination of this woman the other day to D.C. So the Senate acted. Right. Its act is no or yes or 2,028 pages of Obamacare. That's the Senate. Nonetheless, it still makes, I think, coherent sense to say McCain spoke and this is what he said, and then Landrieu spoke and this is what she said, and Susan Collins spoke. Right. And they're all speaking for the Senate too.
I mean, I think that's right. And there's actually a part of the meeting where there's a public forum and everyone can come up and say whatever they want. And the stuff that's said in the public forum, I think, is pretty clearly free speech. But I do wonder whether that's really the same as what's happening here, right? I mean, this is state-sponsored in all sorts of ways. There's only one person that's allowed to talk. The government has given them the microphone and told everyone else to shut up and sit down. Right? They arranged for these people to pray. They contacted them as clergy. The states arranged this in a lot of ways. And when there's only one person speaking, it seems a little different than that. But that was a good response.
Okay, let me have Colin Littlefield ask our last question for the audience, and then I'm going to ask both our participants to handicap what you think the court's actually going to do with this.
Okay, that's good.
My question is for Professor Bradley. It concerns Marsh against Chambers. So the majority opinion in that case relied exclusively on the historical tradition of legislative prayer to reach its conclusion. It ignored, as you pointed out, Lemon, Lee, and all the other tests. Professor Lund made a very good point. I think that
he's in my class, by the way. So
yeah, but he's in my class too. So watch yourself, Colin.
Professor Lund made a good point that that just because the founding generation had a certain practice, for example, legislative prayer, that doesn't necessarily show that they thought that was consistent with the Constitution, but maybe they did it for political reasons because it was just politically expedient for them. Certainly you can imagine today that if the president stopped saying, "God bless America," there would be a political firestorm. And I think that on that basis it becomes difficult for the court in Marsh to say that we have this long tradition of legislative prayer, so therefore all these previous generations have thought about the constitutionality of this issue, and they've decided that it's constitutional. So how would you respond to that?
Well, I think there's a lot in that point, and Chris made a similar point. It's certainly true that there's limited probative value today by taking a snapshot of the world in 1789. So that something is occurring at the time the Constitution is ratified is interesting and has some probative value, I think, but not much. For a variety of reasons, which I'll leave aside at the moment. The Supreme Court often, I think too often, takes the view that a snapshot counts a great deal. They do it in search and seizure as much as church-state, or more often, search and seizure. I'd be a little bit more aware of, just a second of your points, a little bit more generous than perhaps you're being, or you may be implying that you think, about the harmony between legislators acting, at least especially early in the Republic, and what they think the Constitution means. Now, that doesn't mean that they have an opportunity by virtue of being the first Congress to kind of liquidate and freeze the meaning of the Constitution. They don't. But I think it's not very likely that you'll get the entire body, that is by a majority vote or even a large majority, supermajority, vote for this bill or that practice, while that same majority thinks, consciously entertains the thought, this is unconstitutional, but we're doing it anyway. So I think that it's likely to be valuable information about the original understanding, what was the practice at the time. But the question is, what was the original understanding of the Constitution, not the original practices of the legislators. That latter can shed light on the original meaning of the Constitution, but it can't do any more than that. It's the meaning of the Establishment Clause that's the issue. And it's quite true, as Chris suggests, and you're saying too, Colin, it's not a valid argument in law, nor should it be, to say something has gone on for a great deal of time. That establishes that it's constitutional. I think a history of unbroken practice from the founding is probative indeed, but it's not right to say it establishes the point. Whether Marsh took that view, I'm not sure. It's obviously a history-laden and dependent opinion. I'm not sure if that's quite all that they said.
Okay, we're just about out of time, but maybe in conclusion, your thoughts about what the court will do, any predictions?
I have no idea. I mean, I think the town is very likely to win. I imagine you might get. So I always do this. I always offer predictions. I'm always wrong. So maybe you should just bet against me. I imagine you're going to get a couple of votes, maybe 3, saying that Marsh versus Chambers should be overruled, and then just 6 on the town of Greece's side. That'd be probably my best guess. I don't even know if you're going to get Justice Breyer on this.
Who writes the majority opinion?
Kennedy or Breyer.
Or Breyer?
Yeah.
Interesting. Okay.
What do you think? You have to offer something.
Yeah. Do I have to say I don't know? I guess I do, right? Well, I don't know, but I think it's very likely, as Chris is right, that a majority will affirm on the basis of Marsh, seeing that they're not prepared to overrule Marsh. They'll affirm the practice, reverse the court below on the basis of Marsh. Being unprepared to overrule Marsh, I think that the opinion, I don't know who will write it, will dodge all the real questions because they'll cobble together 6 or 7 votes by simply saying in a kind of more like a proclamation or decree manner than a reasoned manner, this is how we decided Marsh, we said it was okay, we meant it, reversed.
Well, please, Professor Bradley, I might add, if he doesn't mind, is a brand new grandfather. He's had a grandson born yesterday, so congratulations. Like many of you, probably most of you, I spent the afternoon reading the oral argument of last week's case. And if you read that oral argument, I think you'll recognize that today's argument was as good, if not better, than the one at the court. So please join me in thanking Professor Bradley. Thank you.